very good day to everyone. My name is Sanchana Chandrasekhar, and today my group and I will be presenting a problem question on the topic of duress. For context, duress arises when there is an improper exercise of pressure on another to the extent where it would cause a person to act contrary to their own will and submit to a situation not of his own volition. Justice McHugh, in the case of Crescendo Management Party Limited v Westpac Banking Corporation, stated that a person who is the subject of duress knows only too well what he is doing, but he chooses to submit to the demand or pressure rather than take an alternative course of action. Due to this, duress has been established as a vitiating factor and a defense in a contract such that if duress is present in the contractual process, the contract will be voidable. This allows the victim of duress to either affirm the contract, which renders it enforceable and binding. The victim also has the option to rescind the contract or set up duress as a defense when being sued and counterclaim for the rescission of the contract, where in both cases, the courts will then seek to restore the parties to their original states, respectively. Duress in the UK is defined and overseen by various authors such as Trital, McKendrick, as well as overseen by common law. However, in Malaysia, this concept is governed by statutes under the Contracts Act 1970, though UK common law is still recognized. It is worth noting that the term duress is known as coercion in Malaysia, defined under Section 15 of the Contracts Act, where coercion is said to be committing or threatening to commit an act forbidden by the Penal Code or unlawfully detaining or threatening to detain property with the intent of forcing someone to enter into an agreement. Additionally, if a person's consent to a contract is caused by coercion, the contract is voidable at that person's option, as set out in Section 19, subsection 1 of the Contracts Act. Therefore, the same bars to rescission apply in Malaysia as they do in the United Kingdom. So for the purposes of this question, the duress category of interest for these two issues we will address would be that of economic duress. According to McKendrick, economic duress arises where one party uses his superior economic power in an illegitimate way so as to coerce the other contracting party to agree to a specific set of terms. Under Malaysian law, economic duress is covered under the previously mentioned Section 15 of the Contracts Act. So relating to the question, the primary approach our group has chosen to discuss for the English law aspect of both segments revolving clumsy core is the modern three-part test to establish economic duress under the case of DSND Subsea Limited v Petroleum Geoservices ASA. As for Malaysian law, reference will be made in accordance to the Contracts Act as well as local judicial decisions to come to a consensus on whether or not Clumsy will be able to set aside its contracts with the UK Dock Workers Union and Greedy Carriers Limited, respectively.
Clumsy Corp is a London-based company specializing in organic skincare products.
My name is Mr. Clumsy, founder and CEO of Clumsy Corp, and I make a living off of selling premium skincare products to my affluent clients in the UK. Most of my products are sourced from a country called Dystopia, but you didn't hear it from me, but they have some questionable labor practices.
Oh, Mr. Clumsy, I really need your help to manufacture your product as door gift for my lavish gala that I'll be having soon. I know it's March already, but we need this done as soon as possible.
Yeah, I guess we could make that happen.
Mr. Clumsy agreed to her request despite the fact that the inventory was critically low, necessitating the immediate importation of additional products from Dystopia.
Mr. Clumsy, I regret to inform you that the UK Dock Workers Union refused to unload your product. because it's being imported from a country with poor labor practices.
Oh no, but I do need it very desperately.
We could help you, but for a small fee.
I'm gonna call my sister. Hello? Please release a statement to the union saying that we are paying under protest and we reserve our rights.
In April 2024, the union's actions were ruled unlawful by the courts.
A very good day, my name is Emily and I'll be addressing the UK law application on the first segment of the issue. Economic duress arises when one party applies economic pressure on another party to enter into a contract or by threatening to break an existing contract if the other party does not agree to its variation or compromise. Although there is no pre-existing contract beforehand in this case, the case of Universal Sentinel 1983 would apply here, which shows that there was a clear case of economic duress. In the Universal Sentinel, there was no pre-existing contract between the International Workers' Federation and the Universal Sentinel, but they threatened to lift the blacklisting only if they entered into agreements to pay a welfare fund. In our current question, similarly, the union refused to unload the imports from countries with poor labour practices unless Clumsy Corp paid an extraordinary annual unloading fee of £100,000 to the union. So moving on, whether this case would fulfill the elements of economic duress. In the 20th century, cases such as the Atlantic Baron 1979, Universal Sentinel states that the elements of duress were firstly the coercion of will and illegitimacy of pressure. However, we will be following and applying the modern three-part test under the case of DSND Subsea Limited and Petroleum Geo Services ASA 2000, where this case stated three elements to fulfill. Firstly, no practical choice. Secondly, illegitimate pressure. Thirdly, pressure is a significant cause. So applying the three elements to our current scenario, we will be applying it one by one. Under the first one, no practical choice, the Universal Sentinel case directly emphasizes that there must be pressure and the practical effect of which is the compulsion or the absence of choice. So Clumsy Corp needs to prove that there was no practical choice available to them. In the problem question, it states that members would refuse to unload the imports from those countries unless Clumsy Corp paid an extraordinary annual unloading fee to the union. So this definitely left Clumsy Corp with no choice. If they did not pay the annual unloading fee, then their goods would not be able to be unloaded. So the first element is already fulfilled. Secondly, there was illegitimate pressure. There was evident illegitimacy of pressure because the union demanded the payment as a condition, which is stated and in the problem question that it was held by the courts to be an unlawful act. In the problem question, it states that in April 2024, the union's actions were ruled unlawful by the courts. So this is actually supported as well in the case of R&AG, England and Wales, where Lord Hoffman stated an unlawful act of duress included a threat of any form of unlawful action, and this would render it to be illegitimate. So since there was a clear unlawful action here, it definitely fulfills the element. Moving on to the third element, that pressure is a significant cause, the case we'll be relying on is the Evier-Lark 1991, where Lord Gough mentioned economic pressure may be sufficient to amount to duress if it is illegitimate and has constituted a significant cause inducing the claimant to enter into the relevant contract. Clumsy Corp has stated that they were paying the £100,000 under protest because they were left with no alternative choice if they wanted the goods to be imported. They stated, "We are paying under protest and reserve our rights." So they specifically stated that they were paying under the pressure, which was the significant reason to entering the contract. So we can sum up from the above that all three elements of economic duress were fulfilled. And in regards to remedy, the reference we'll be making is to the Universal Sentinel case once again, where the court mentioned that the remedy for economic duress is not an action for damages, but an action for restitution of property, money, and avoidance of any contract that has been induced by it. Hence, in our current case, Clumsy Corp would be able to recover his money, and the contract induced under duress would be deemed voidable. So that will conclude the UK application on the first segment. Thank you very much.
Good day, my name is Megan and I will be elaborating more on what Sanjana has discussed briefly before. In these circumstances, we'll be taking a deeper dive into the subcategory of coercion called economic duress. Though the fundamentals of coercion are still present in economic duress, unlike the above mentioned, there have been many conflicting cases following economic duress, and whether Section 15 or the statute in general is applicable under it. In Perlis Plantations Berhad versus Muhammad Abdullah Ang, Justice V.C. George stated that the Contracts Act 1950 indeed does not provide any other form of coercion outside of what is codified by Section 15. Due to this, it can be pointed out that there is a lacuna in Malaysian law, and therefore economic duress is heavily reliant on precedents as common law as Section 3 of the Civil Act 1956 allows. In the case of Pao On versus Lau Yulong, it was established by the Privy Council that economic duress could be recognized on the basis that it amounts to a coercion of will, and that the act of entering into a contract was an involuntary one, and that the innocent party was left with the lack of practical options. This principle was further supported by Justice Lau Hop Bing in OCBC Securities Malacca, Sendiri Berhad versus Koh Hee Huat, stating that though courts will be hesitant to enforce this concept, the innocent party will be allowed to render the contract voidable as long as the element of free consent is challenged. In more recent case, Amar Sendirian Berhad versus IDG Sendirian Berhad and another, the High Courts held that it was indeed a case of economic duress, even overlooking Section 15 of the Contracts Act to come to their conclusion. Firstly, in this circumstance, Clumsy's consent cannot be regarded as free, as they were given an ultimatum to either pay £100,000 or have their ordered goods withheld from them indefinitely. In addition to that, Clumsy faced a predicament that left them with no practical alternative, as their inventory was critically low. This satisfies the criteria of coercion of will as well as illegitimate pressure. In favor of Clumsy Court, there was indeed a reliance and an element of desperation towards receiving the goods, as the contrary would result in them facing a great loss in profits. In Tech Guan Trading versus Hydrotech Engineering, the claimants sued the plaintiff for not paying the increased price of the goods, though there was an agreement to do so. The goods had been supplied, but payment was outstanding. Moreover, the plaintiff raised a defense of economic duress, but was subsequently rejected by the courts, as it was merely an exercise of free will for the supplier to increase their price. However, in this current case, as illegitimate pressure is present and Clumsy had taken the necessary steps to display their protests and to reserve their rights, it serves as further proof that payment was made involuntarily. Hence, the contract will be voidable as a whole. Lastly, a possible remedy to conclude this case would be in reference to Section 65 of the Contract Act, where should Clumsy opt to rescind the contract, both parties must return any benefit that they have received during the contract, effectively restoring all parties back to their original positions and statuses. Fortunately for Clumsy, Clumsy will be entitled to a restitution of the £100. Thank you.
Another one of our business ventures is selling UK-made skincare products to retail shops in Wales.
Deliveries are managed by Greedy Carriers Limited under a 2-year contract set to end in September 2024. In March 2024, Clumsy secured several profitable long-term contracts with a new Welsh retailer. And upon learning of this, Greedy Carriers sent Clumsy a letter.
Assistant, hi, it's me again. How are your kids? Never mind. Respond to Greedy. Tell him that we are very unhappy with your conduct and that we reserve our rights.
Despite the exchanges, Clumsy paid an additional £150,000 to Greedy Carriers before the contract's expiration in September 2024. And in October 2024, Clumsy contracted with a different logistics provider.
Good day, Mr. Hatcher. My name is Pang Chenjar, and now I'll be presenting on the second segment in English law. The issue here is whether Clumsy is able to recover the sums paid to Greedy Carriers, and it involves economic duress. As mentioned earlier, economic duress arises when one party places economic pressure to the other party, either to enter into the contract or threatening to break an existing contract if the other party does not agree to its variation or compromise. Clumsy and Greedy Carriers were in an existing contract which ended in September 2024. To prove economic duress, Clumsy must show that there was illegitimate pressure, which leaves Clumsy no practical choice but to succumb to the threats. As mentioned, Clumsy and Greedy Carriers have an existing contract which ends in September 2024. However, Greedy Carriers is attempting to break the contract with no reason stated to Clumsy. The threat involved here is Greedy Carriers stating they will cease all deliveries unless a surcharge of £500 per load was paid, starting in April 2024. The modern three-part test for economic duress is found in the case of DSND Subsea Limited versus Petroleum Geoservices ASA. First, the pressure must leave the claimant with a lack of practical choice. Second, the pressure must be illegitimate. Third, the pressure is a significant cause which induces the claimant to enter into a contract. First, Clumsy must prove that there was no practical choice but to comply with the threat from Greedy Carriers. It was stated that Clumsy is unable to find an alternative carrier and reluctantly consented to the threat. According to the Universal Sentinel, the courts would look at whether the victim had any other practical alternatives. To apply, the consequences of Clumsy not delivering the skincare products will result in losing profits from new Welsh retailers. This leaves Clumsy with no choice but to agree to the variation. Second, Clumsy must also show that the pressure was illegitimate. In R versus Attorney General of England and Wales, Lord Hoffman's obiter dicta expressed that the threat of any form of unlawful action will be regarded as illegitimate. Cooney and Sanderson mentioned that the law now acknowledges what was previously overlooked under the overborne will theory of duress. In other words, pressure can still be lawful and legitimate even if it is highly coercive. To apply, the threat from Greedy Carriers is unlawful as they are bound by the contract which ends in September 2024. Greedy Carriers did not provide any legal justification as to demanding a surcharge. Since the threat is unlawful, the pressure will be illegitimate. Third, the pressure is a significant cause which induces the claimant to enter into the contract. Clumsy agreed to pay additional £150,000 because there were no practical alternatives left. In Atlas Express versus Cavco, the court held that there was economic duress when Cavco signed the agreement because they had no practical alternatives. To apply, after paying, Clumsy has clearly expressed that they were unhappy and reserved their rights. This emphasizes that Clumsy did not voluntarily consent to the variation. The illegitimate pressure was the reason why Clumsy had agreed to the variation. At the time of agreeing to the variation, Clumsy protested against the variation and stated that they will reserve their rights. Clumsy promptly switched carriers after the contract with Greedy Careers expired, showing there was no affirmation of the contract. Therefore, Clumsy did not waiver their rights through protesting against the variation. Ultimately, Clumsy is entitled to recover £150,000 from Greedy Careers. All three elements of economic duress are satisfied, and their rights were expressly reserved at the time of agreeing to the variation.
Good day. Moving on, I will be looking at the Malaysian position in this situation. In this situation, it is clear that coercion is present as defined in Section 15 of the Contracts Act 1950. Now, we know that coercion includes threatening to commit any act forbidden by the Penal Code or unlawfully detaining or threatening to detain property with the intent to cause someone to enter into a contract. In the case of Tech1 Trading and Hydrotech Engineering, the plaintiff agreed to sell round bars to the defendant at the initial price of 1,180 ringgit per ton, as stated in a document dated on 27 July 1990. Later, the plaintiff claimed that there was a typo and the actual price would be 1,244 ringgit per ton. Allegedly, the defendant had agreed to the higher price on a later date on 18 September 1919, as they required the bars to produce concrete that they had already committed to supply, and there was no time to look for another source of supply. Subsequently, the defendant did not pay the balance remainder, and the plaintiff had sent a notice of demand to the defendant. However, no reply was received. Following up, the plaintiff then claimed for an action. The defendant had argued that the agreement to pay for a higher price was obtained through coercion. However, it was found that no offence under the code had been revealed. The plaintiff's refusal to supply the round bars at 1,180 did not amount to unlawful detention of property, as the plaintiff was just exercising his legal right over its own property. Hence, it was found that there was no coercion. However, in this case, between Clumsy Corp and Greedy, there had been an existing contract until September 2024 to continue the delivery of goods. Greedy's threat to cease delivery directly violated its existing contractual obligation. This is to be distinguished from the case before, where he only refuses to supply. While services are literally property, threatening to stop delivery unless a surcharge was paid can be seen as threatening to detain property. Hence, it is likely that Clumsy will be able to prove that they have been coerced into paying the extra 150,000. In addition, there was no intention of causing coercion proven in the case prior. However, in this case, intention shall be discussed. Clearly, Greedy Carrier had intended for Clumsy Corp to pay the extra £500 per load. Very clearly, Clumsy had no alternative, having no choice but to pay this extra 500 per load, causing them to be coerced into entering this new agreement. Very clearly, we have established that there is coercion present. Moreover, Section 14A of the Contracts Act 1950 says that consent is not free when it is caused by coercion. Very clearly stated by Clumsy Corp that they were unhappy with their conduct and they reserved their rights, showing the lack of free consent, proving coercion once more. Therefore, in order for Clumsy to obtain the extra 150,000 paid, they can make a claim under Section 73 of the Contracts Act 1950. This section states that a person to whom money that has been paid or anything delivered under coercion must be repaid or returned. In the case of Chin Nan Wee Development and Tai Kim Chu, the defendant had signed the sale and purchase agreement with the plaintiff for a purchase of a house. Later, the defendant threatened to cancel the booking if the plaintiff does not pay an extra 4,000 ringgit. In turn, the plaintiff did pay the extra 4,000 ringgit but sought to recover it later on the grounds of coercion, relying on Section 73. It's found that the plaintiff was able to recover the 4,000 ringgit and that there was coercion. It was also found in this case where coercion need not necessarily be according to the definition of Section 15 as discussed before. What it means to say that Section 73 of the Act should be given its ordinary and general meaning, since there is nothing under Section 15 which says that the word coercion should have the same meaning throughout the Act. Hence, In this case, even if Clumsy was not able to prove coercion under Section 15, they would still be able to recover the £150,000, despite if they were not able to prove coercion under Section 15. It would still be possible for them to recover this sum of money. In this case, Greedy had sent a letter to Clumsy saying that they would cease delivery unless the surcharge was paid. Clumsy, unable to find an alternative, was coerced into paying this extra £150,000, having no choice. Hence, via Section 73, Clumsy can seek to recover the additional money paid to Greedy, and it is likely that this claim will succeed, as it is very clear that Clumsy was coerced into having to pay the additional money. Therefore, there should be no problems. Moving on, it should be noted briefly that the Contracts Act does not define economic duress, only what is defined under Section 15. This was stated in the case of Perlis Plantation and Muhammad Abdullah Amin. However, the doctrine of economic duress is applied in case law, as is seen in the case of Bergamo Development and Act Development, where courts did recognize that there was economic duress and held that the contract was voidable. Moreover, in OCBC Securities and Co P Huat, it was stated that our courts are very slow in invoking to import the concept of economic duress unless there is a positive evidence to that effect. And even then, it has to satisfy the guidelines given by the Privy Council in the case of Pao On and Lau Yu. That's all from me. Thank you.
Good day, Mr. Hachern. My name is Ariana Carmel, and I will be summarizing both segments and outlining everything that we have done in this video. Based on today's discussions, we have seen how both jurisdictions, Malaysia and the UK, approach this problem centered around economic duress. Sanjana, who delivered the introduction, defined economic duress as a whole. Subsequently, the first segment was done by my friend Emily, and she made reference to the Universe Sentinel case, by which, under the English position, made a good argument for Clumsy Corps to recover their losses and render the contract voidable. This is followed by Megan's portion on Malaysian law. This part involves quite a lot of Malaysian law cases, but ultimately, according to Section 65 of the Contracts Act of 1950, allows both parties to be restored to their original position. This reaffirms our stance that Clumsy is entitled to receive his money back. Looking at the second segment, my friend Chanja explains that in order to prove economic duress according to UK common law, 3 elements must be satisfied, all of which the aforementioned situation did in fact do so. Finally, my friend Jaini discussed coercion under Malaysian law, quoting both the Contract Act of 1950 and the Malaysian Penal Code to once again solidify our position that Clumsy is entitled to claim his money back in this segment as well. Concluding this video, it is important that the outcome of this problem question reflects principles pertinent to the real world. Ideals such as businessmen, particularly Greedy Carriers Limited in the second segment, that are dealing at an arm's length ought to be held to their end of the bargain. With that, thank you for listening.